Okay.
This is Trump, isn't it?
That's
Don't start.
Not
sure who 419 is. Oh, we got
Ooh.
someone on phone.
I am.
Greer took a trip too.
yeah. Y'all, I'm gonna have to drop out for a minute. I've got dinner in the oven, but I will be back. Okay, so I don't want to be rude.
And me
So
too.
it's
I'm going to be
up
off
there.
and on, but I'll still be listening on. So, okay, just so that you know.
Oh, okay. Well, actually, Mark is recording this, so if you wanted to listen later, you could.
No, I will still listen out, but I might be in and out. So. Stephanie,
Well, I'd say it's 7:02, Amy. So
Yeah, no, go ahead. It's fine.
Before we get started, though, David, Amy, which one of you would feel comfortable with me making the host when I decide to drop out? I'm going to be on for another probably 15, 20 minutes just to make sure everything's going okay. If you had a preference.
well, I hate for Amy to do it, but I've never done it. So
Oh, okay. Make me the host. That means that if a latecomer comes in, I'm going to have to admit them from the waiting room.
where would I do that?
There's a little, at least on my computer, there's a little line across the top that says someone's in the waiting room, admit them.
That's why I was going
Oh, okay.
And you have to click admit.
I can
That's
do
why I
that.
was going to stay on for another 15.
You wanna
Okay.
do that?
Yeah.
Okay, David will do that.
Why don't you let me do it?
And you just have to leave me co-host, I guess, so I can do the screen share, but I don't have to do anything else.
Yeah, you'll stay co-host. I mean, just when I make somebody the host, I mean, just they have the ability to make people co-hosts. I don't think either one of you do, but you basically have all the power except for one thing. So.
I'm happy to share. I have enough power when I'm teaching a class. I don't need it in the evening.
Well, why don't we go ahead and get started? Thank you, everybody, for being here in this virtual space for what I know is going to be a rewarding hour and a half. We will get you out of here by 8:30 so you can go grab a bite to eat if you haven't eaten already, so you can go glue yourself to the television for the wonderful debate tonight. So I think everybody knows Amy and knows how devoted she has been to the church and to the RE program and to this forum, which is this third or fourth time you've done this?
Actually, I don't remember.
Okay. Well, I would just say go ahead and take it away. If you would all please mute yourselves while Amy is giving her presentation. And then if you want to ask her a question, please do that in the chat. And I will
Oh, David, I accidentally muted you along with everybody else.
Didn't know his own strength.
Nope, still muted.
Unmute, David. Your lips are moving.
There we go.
Now, all right. So while we're all muted, thank you for agreeing to do that. What we're going to do is, if you've got questions during the course of the presentation, if you would put those in the chat, and I will interrupt Amy with your question, and she will answer it in due course. And then after her presentation's over, we'll open it up, okay, to live Q&A. That way, we'll be sure we get through the question. We'll get through the presentation. Is that okay with everybody? Okay, Amy, take it away.
Thanks very much, David. You all hear me? Okay, great. You don't need to see me because you're going to see my outline in a minute. The lights in this room are a little strange, but as David said, I've done this, I can't now remember how many times, usually to very satisfied audiences. So I hope that I will make it yet another satisfied audience tonight. My talk only takes about 45 minutes, so we'll have plenty of time for questions at the end. But if you're afraid that you might forget a question when I'm 10 minutes into my talk, just put it in the chat. If it's relevant to what I'm talking about, I've already told David to interrupt me. I'm happy to be interrupted. But if it is a more general question, he may defer it until the end of the 45 minutes and I'll answer it at the end. All of your questions will get answered. And if it looked as if my screen just went black, it's because I have a long-haired black cat that just walked across it. With any luck, he will not walk across the outline, which I am about to show you. We'll see. Okay. Without the cat. The first thing I want to say is I know that a number of you are still working full time. And I just wanted to say one thing that I'm not going to cover very much in this talk, but I'll be happy to talk with you about it privately at some point. One of the jokes that estate planners tell each other is that all of our clients in midlife, people in their 50s, 40s, 50s, 60s, and so forth, seem to assume that they are going to work very hard and then they're going to retire. And maybe a week after they retire, they're going to die. Now that sounds ridiculous because nobody expects to die a week after they retire. But what the estate planners mean is nobody plans for what probably will be 20 or 30 years of retirement, during which you have to have the finances to live because you're not working anymore. That's a part of estate planning too. In order to keep my talk to 45 minutes, I'm going actually to talk mostly about old age and after death. But I just wanted to assure those of you who are not ready to retire and proud of it, that there is a part of estate planning that is probably the most underdone of all estate planning. And it is the part where you figure out how you're going to live and do all the traveling you've always wanted to do and all the other hobbies you wanted to take up after retirement, after you're 65, when you're no longer getting a regular paycheck. There are ways to do it. There are guideposts of how much money you should have saved at different times in life. And as I said, I'd be happy to talk about that, but that by itself would probably take 45 minutes. So I'm going to stick with more traditional estate planning. The first reason why you should have a will, and usually this is the first question people ask me, is I don't need any estate planning because I don't need a will. You might, because it might surprise you why you need a will. The first reason you might need a will is because if you don't leave a will, every state in the United States has a statute that says how your property will be divided when you die. It is called the statute of intestate succession, this bold writing on at the top of the outline. And intestate succession just means distribution of property when the owner dies without a will. And most people assume, particularly if they're married, that if they died without a will, all their property, of course, would go to their surviving spouse. Unfortunately, in about half the states in the United States, and Tennessee is in that half, that statement is not true. All your property does not go to your surviving spouse. Now, before I go any farther, I need to say two things. The first is that when I talk about intestate succession, I am only talking about property that is titled only in one name. So if the deed to your house just has one name on it and it's your name, the property would pass by intestate succession when you died. If your bank account only has your name on it, same thing. If you own property jointly with someone else, the someone else, if he or she survives you, will receive the property. We'll talk about that kind of property in a little while. First, I want to start with property that's owned only in one name. The second thing I want to make sure everybody knows before I start saying this, because it might save you a couple questions in chat, is there's a refrain in this outline, and it goes like this. If you don't like what I say, write a will. Because a properly executed will supersedes, trumps all of the statutes that I'm going to talk about. So if you don't like the statute of intestate succession, write a will, your property will pass under your will. It will not pass under the statute. But usually people want to know what would happen if they didn't write a will first, and that's what I'm telling you. So in Tennessee, if you die survived by a spouse and you have no children and no grandchildren, then all of the property that is titled only in your name does pass to the spouse. But if you have even one child, or if the horrible happens and your child dies before you and you have grandchildren, the property will be divided so that the spouse will get half and the children or grandchildren will get the other half. If you have two children, or again, descendants of children, the spouse gets a third. Now, I don't know how you all feel, but when I was young and married, I didn't think very much of the idea that my husband might own a third of my house and our children, who would have been minors at the time, would own the other 2/3. That didn't make any sense to me, and it doesn't make any sense to most people. Why the statute does that is largely historical, and it doesn't matter because there isn't any room for interpretation in the statute. If you have 2 or more children or lineal descendants and a spouse, the spouse gets a third, the children own the rest, and it's a third of every asset. So the spouse has a third of the house and the children have 2/3. The spouse has a third of the bank account, the children have 2/3, and so forth. And it doesn't matter if the children are minors. If the children are minors, somebody will have to be appointed to manage the property for them. And that might be the surviving spouse, which sounds like it would solve the problem. And to some degree it does. But in order for someone to be appointed, there has to be a court proceeding. And I can't imagine why anybody would deliberately leave their estate in a way that would require a court proceeding. That doesn't seem to make much sense. So if you don't like what I said, as I said a minute ago, you write a will, you leave all your property to your surviving spouse, and he or she actually does survive, then all of your property goes to your surviving spouse under the will. Now, the will does have to be probated, but we'll talk about that in a minute. However, it does eliminate the issue of divided property. Everything goes to the spouse. Presumably, the spouse takes care of the children. Or if the children are adults and on their own, the spouse has a nice retirement on the property that you and he or she amassed together. And that's usually the way most married people would want it. Now, as I said, and I'll get back to this in a minute, at the top of page 2, I tell you that intestate succession does not apply to property that 2 people own together, even if they are husband and wife. And I'll go back to that in just a minute. But first, I want to mention something else that's actually under heading 2 on the second page. The law of intestate succession is extremely literal. When I say spouse, I don't mean committed partners. I mean people who are married, legally married under the law of the state where they lived when they got married. Now, Tennessee does not recognize common law marriage. So even if you have been together for 10 years or 15 years or whatever the consensus is about what common law marriage means, doesn't mean that in Tennessee, because Tennessee doesn't have common law marriage. The one exception to that is if you lived for the prescribed period of time in another state. For example, Georgia does have common law marriage. If you were already considered spouses under that old state and then you moved here, you're still considered spouses because of the old law. But Tennessee itself, if you've lived all your life here, Tennessee does not have common law marriage. So marriage means marriage and spouse means spouse. Similarly, children means children. It means the first generation of your family younger than you, whom you either gave birth to or you legally adopted. It does not mean stepchildren. If you're married to someone who was married before and you have stepchildren, my son is in that position. In the eyes of the intestate succession law, he doesn't have any children because they're his stepchildren. He'd have to legally adopt them for them to be children. It doesn't mean foster children. It doesn't mean people that the court gave you legal custody of. They are not children. It doesn't mean grandchildren, nieces and nephews, anybody in your family that you're raising. It only means children. Now, again, if you want to leave all your property to your grandchildren, this isn't a problem. It just means the intestate succession statute won't do it for you. you have to write a will. And that's what I meant before when I said, if you don't like what I say, write a will. So you just have to know, in the law, we call the rule that applies if you don't do anything at all, the default rule. So intestate succession is the default rule. If you write a will or write a trust, and I'll go into the other kinds of things you can write later, they supersede whatever's in intestate succession. It's only the folks who procrastinate and never do any estate planning that find that their estates are eventually distributed under the law of intestate succession, because the property has to go somewhere. And if you don't tell us anything about where you want it to go, then it will go under the law of intestate succession. And I will tell you that it can make a mess. My grandfather was a very well-educated man. He founded a bank. He and his friends founded it in the roaring 20s and actually got it successfully through the Depression. It didn't close. Everything was fine. But somehow, despite all of his financial acumen, he seemed to think that if he did an estate plan, he would die as soon as he signed his will. Unfortunately, he didn't do any estate plan and he died anyway. So his property all passed by intestate succession. He was married twice. My birth grandmother died young and my step grandmother survived my grandfather. So he had two families and it was quite a mess. And my mother, being the oldest daughter on both sides, so to speak, ended up as the person who had to administer the estate. So if you don't want to leave a problem like that for your descendants and friends, I strongly suggest that you do some estate planning. And if not a will, perhaps something else. Now, property that is owned jointly, as long as there's a survivorship provision in it, will pass automatically to the other person who owns it. Most spouses own their property in something called tenancy by the entirety, which is described at the top up here. A tenancy by the entirety is basically joint ownership between spouses. And again, why we call it by such a funny name is largely historical and it doesn't matter. But if two people who are married own property as tenants by the entirety and one of them dies, the other automatically gets it. So if you own all your property jointly with your spouse, the spouse is going to get it. That doesn't mean you shouldn't do any estate planning. Because I don't know about you, but I don't know which one of you is going to die first. I know the statistics, but there's always an exception to statistics. And the person who survives owns property alone because there is no longer another survivor. So that person still needs a will. And since we don't know who is going to die first, most lawyers will recommend that even people who own all their property with a spouse as tenants by the entirety should still write a will for the eventuality that either of them might be the survivor. And of course, immediately after you've lost a spouse is not a good time to be doing estate planning. So you should do it in advance anyway, even if you don't know who is going to be the person who actually survives. A word about joint tenants with right of survivorship, which is a very common kind of joint tenancy between folks who are not spouses. I have lots of clients who are absolutely convinced, they're widows or they're older people who never married, and they're absolutely convinced that they need to own all their property as joint tenants with right of survivorship with a younger family member. So they title their bank account and their home and their car and everything else as joint tenants with their child, with their niece or nephew with right of survivorship. Now, in a harmonious family where nobody takes chances, that's probably just fine. The problem is joint tenancy means exactly what it says. Each person in a joint tenancy can sell his or her half of that asset without the other one's permission. Each person in a joint bank account can take out half the proceeds without the other one's permission. Worse than that, if one of them runs up debts, a creditor can come in and take half the value of the house, the farm, the bank account, whatever it is, without the permission of the non-debtor tenant. So be really careful before you decide to put somebody else's name other than a spouse on a valuable asset. I get a little bit crisp sometimes with my clients and they can't quite figure out what's wrong with me. Somebody will come into my office and say, well, but I have to have all my property as joint tenants because I want to avoid probate. And my answer to that is, really? Why? And of course, the answer, why what? Why do you want to avoid probate? At which point they really think I've lost it. Well, I haven't lost it. Probate in Tennessee is not expensive. It does not take a long time. And sometimes writing a will is exactly what you need to do. Now, if you noticed when you got the outline, there's a cute little legend at the bottom of each page that says this is not estate planning advice. There's a reason for that. I can't give 18 people the same advice on estate planning. Nobody can. You need to talk individually with a lawyer and see if you are the one person who really should avoid probate. But if you are, joint tenancy is not the answer. There are other tools to use, not joint tenancy, to avoid probate. The most common one is to create a trust while you're alive that has provisions in it that continue after you die. And the assets simply are distributed by the trustee after your death without probate. And if that is something that interests you and you want to talk about it with a lawyer who does private estate planning, or you want to ask me some questions about it later, that's fine. That is a good way to avoid probate. But I would not recommend using joint tenancy without asking a lawyer because it does have those pitfalls that can cause problems for you during your lifetime, let alone cause problems for your family after your death. Number 4 has another highlighted phrase in it. I'll just mention it. I said before that if you leave your property by intestate succession and a minor child ends up inheriting a portion, the child can't buy and sell real estate. So someone has to be appointed, and that person is called a guardian of the property. But that requires a court appointment in order for there to be a guardian. Now, very often the guardian is the surviving parent of the child, and the situation is relatively simple. But I don't know about you all, but I don't like to leave that kind of thing to chance. I would prefer to plan for it in advance. And the way to plan for it in advance is either to leave all the property to the responsible adult, to the surviving spouse, or to leave the property in a trust, either created during life or in your will, so that there is a professional money manager that can take care of the property for the child. Now let's get to other reasons besides intestate succession why you want to leave property in a will. We already talked about leaving it to different people or in different shares than would occur under intestate succession. But there are a couple of other really good reasons. One of them is to appoint someone who will handle all this. After you die, all of your assets are in a kind of limbo, and someone has to figure out what they are, what your debts were, whether there's any tax due, all those things. Now, I don't know the details of your family situation, but in my family, we have two kinds of people. We have the people who would do a really good job at administering the estate. And then there are the people who think they would do a really good job at administering the estate, and they aren't the same people. So I want to make the decision who's going to administer my estate so that my son and his family don't have problems with the person who's taking care of the assets. Now, of course, one way to do that is to appoint my son, which is a good solution. But you want to have the say in who is appointed. If you don't appoint anybody, I mean, when you die intestate, obviously you haven't done any estate planning. If you don't appoint anybody, someone in your family can go into court and get an executor appointed. But again, that's leaving the choice of executor to somebody other than you. And it could simply be somebody who's not even related to you. If you leave debts, a creditor can come in and ask to have an executor appointed. And I know that that person is very unlikely to be a member of your family. The statute says a creditor has standing to have an executor or personal representative appointed. So you don't want to leave that blank, so to speak. You do want to make the appointment yourself. Another person that you definitely want to appoint yourself is someone to raise your minor children if you have any. Again, there are people in my family who think they would do a very good job, and then there are the other people who would actually do a very good job, and they're not the same. So when my son was a minor, I had a provision in my will that said who would be his guardian. Now that's one of the few situations here where I can't promise you that your will be observed. Most states, and Tennessee is one of them, have very strict laws that say the judge must take into account the best interests of the child. And if you appoint someone and there's a fight because family members don't think that person is the best person for the job, I can't guarantee you that somebody other than the person you appoint might not actually end up guardian. But it's kind of, you don't know until you try. You should appoint someone and say why. And you should also do something else which people don't think about or think they shouldn't do. I recommend to all of my clients, and I've done this myself, I never appoint anyone to any of these positions without talking to them first. So if I'm going to name my son as personal representative in my will, I'm going to tell him first and ask him if he wants to do it. Because if the answer is no, he cannot be forced to do it after I die. I might as well know that now. I'll pick somebody else if he doesn't want to do it. Same thing with a guardian. If you nominate your brother and sister-in-law and they say, you know, we're getting on in years, we really don't want responsibility for an 8-year-old if something happens to you, that's their privilege. Might as well know it now rather than having them say that to the judge after you're dead and can't appoint somebody else. So ask everybody that you're going to give a responsibility to whether they will accept that responsibility. And ask them periodically. People think they write a will once and it's done. A will is completely revocable until you die. You can write as many of them as you want, and the only one that will be probated is the one that has the very latest date on it. So if you write 8 wills, the 8th one will be probated, and the other 7 will be, the doctrine in the law is that they're just scraps of paper. And it's literally called the scrap of paper doctrine because the will has no effect until you die. Another reason to leave property in a will, and another reason to talk to people before you do it, is to create a trust for people who are either too young, too old, or simply financially irresponsible to take care of the property themselves. In the default rule in the law is that any person 18 years old or older is considered competent unless there's a court proceeding to prove that he or she is not competent. So you don't ever want to leave property outright to someone who can't handle it themselves. You want to nominate somebody who'll do that. And the somebody is called a trustee. But again, you want to ask the person whether they want to be trustee before you name them, because if they refuse, the judge can't force them to be, and somebody else will have to be appointed in that trustee's place. The other thing, while I'm talking about people who have jobs to do, the other thing that's a really good idea to do is to name more than one person and name them in order. So I name X, and if she should fail for any reason to act or should die, then I name Y. And the judge will automatically appoint the people in the order in which you named them. We always tell our clients to name what we call a backup. There's always an alternate besides the person who's the main person. One of the most important reasons that people don't often think about to create a trust, even if you have relatively small valued assets, is if one of your beneficiaries is a person with a disability of some sort, and that person qualifies for any kind of public entitlements, such as SSI, supplemental security income, or TennCare, any public entitlement that is what we call needs-based, which means you only get it if you are a person of modest means. Well-off people don't get it at all. So TennCare and SSI. You need to put your property in a special kind of trust for the benefit of that person, even if that person could manage the property alone. And the reason is that if you don't, the assets that you leave that person directly are considered what is called an available resource, which means they get disqualified from the public benefits. Now, they're only disqualified for as long as they have the available resource. And if it's a small amount of money, you might say, well, what difference does that make? It makes a lot of difference, and this is why. Once you are disqualified from a public plan like TennCare, it can sometimes take 2 years to get requalified. Who is going to pay that person's medical expenses while we're waiting for the bureaucracy to realize that he is now destitute again? The reason that you can't answer that question is because it doesn't have an answer. The answer is nobody. So you really, really need to be careful if you have a beneficiary, a person you want to leave property to, but you know that person qualifies for some kind of public entitlements. That really requires careful estate planning. Now, I have to say one thing that really bothers people, and I know it's unpleasant, but invariably when I do these talks, somebody asks me, can I make sure that my ne'er-do-well wife, ne'er-do-well husband never has custody of our children? And the answer is no. You can't make sure. Marital law and estate law don't go together very well. I wish they did, but they don't. If you've been separated from someone for 20 years and you don't even know where they are, or worse, you do know where they are, and where they are is in jail, if you aren't legally divorced, that person is still your spouse. And that means that if you have been married, that is to say, if the marriage ceremony took place at least 9 years ago, even if it took place 20 years ago and for 18 of those 20 years you were not together, if it took place more than 9 years ago, that person has the right to 40% of all the property that is titled only in your name. And the only way to prevent that is to get a divorce. Similarly, both parents of any child are the natural guardians of that child. And the only way to deprive a parent of the right to parent their child is to have a judge declare them an unfit parent. So you can say in your will, I haven't seen my wife in 15 years. I don't know where she is. She's probably in jail, and my mother needs to take care of my daughter. You can say that and the judge will take it into consideration. But if wife comes back and insists that she's a fit mother, there's going to be at least a protracted litigation about it, in which your daughter is going to basically be the pawn in the hand of a bunch of adults who are fighting. The only way to break up a family is to break up the family. You can't do that in a will. So divorce and custody are the two things that will not necessarily be taken care of just by writing a will. Now, nobody wants to talk about this either, but most of us will endure a period during later life when we can't manage all of our financial and personal and medical affairs ourselves. People, this is another one where people act as if it happens suddenly. It doesn't. It kind of happens one molecule at a time. I had a client in Virginia when I used to practice there who said to me one day, I need to nominate someone who'll take care of me when I get old and funny. So that's kind of been my phrase for what happens to people. They get old and funny. If you don't prepare in advance, when you get old and funny, somebody in your family is going to have to go to court, prove in open court, this is a public proceeding, that you're incapacitated, and have someone in the family nominated to act for you. That doesn't sound very pleasant. The last thing I ever wanted to do when I was middle-aged was go to court and say in open court, Your Honor, my father can't take care of himself. Your Honor, my aunt can't take care of herself. You don't want to put your family in that position. So what you want to do is write a document called a power of attorney and nominate somebody to be, it's either called an agent or an attorney in fact. That's the person who acts under the power of attorney. The person, by the way, is not a power of attorney. The paper is the power of attorney. The person is an attorney in fact or an agent. And you simply write it. You don't have, it doesn't require a special ceremony like a will does. You just write it and have your signature notarized. And that person is your attorney in fact and can act for you. You want to be very careful to make sure that if you sign such a paper, It is what is called durable. Durable doesn't mean it's written on very strong paper. Durable means that it will still be a good document even when you are incompetent. Now let's go step by step here. You must sign the document while you're still competent. You cannot sign it once you're incompetent. I have people come to my office all the time and say, you need to write a power of attorney so that I can take care of my mother's affairs. She's incompetent. My answer is, I'm really sorry, but it's too late. Your mother can't sign. If you tell me your mother's incompetent, I have an ethical responsibility not to hand her a piece of paper to sign because she isn't going to understand what she's signing. At that point, we have to have a conservator appointed, which is a court proceeding. But if mother comes earlier and is capable to understand what she's doing, she doesn't need to be about to earn a PhD in physics. She just has to understand that she's giving somebody responsibility to take care of her affairs. If mother comes at that point and can sign the document, it's durable, then it's signed when she's competent or when you're competent, and it continues until the person who signed it dies, even if they're incompetent for a long period of time. I was attorney, in fact, for my mother for more than 10 years at the end of her life because she was incompetent to handle her own affairs for that long. She lived to be 97, and people get forgetful and confused at that age, and she was. Now, one of the common misconceptions is that if you sign a power of attorney, somehow you've deprived yourself of the right to handle your own affairs. That's not true. If I sign a durable power of attorney today, giving my son Carlos the right to act for me, the document will say that he has the right to act for me today. But if he and I agree that I can still act, I can still act. And everybody will take my signature as though there were no document in effect. It doesn't matter. The only thing you're doing is providing for the time when somebody has to take care of you because you can't take care of yourself. So it's a good idea to sign it while you're still competent in order to prevent the family from having to appoint a conservator. You cannot sign it when you're incompetent, but you can continue to handle your own affairs for as long as you want. Nobody's going to question your ability to handle it just because you sign a power of attorney. We've talked about joint property.
Amy, is that attorney, in fact, another appointment that you should have a list of possible people to do?
Yes, absolutely. You appoint an alternate for all of these. In fact, 2 alternates if you can think of 3 people. That'd be great. There are...
Amy, excuse me.
Yeah, go ahead, David.
Laura is asking, is the power of attorney something that can be updated over time similar to a will?
Yep, you tear it up and throw it away and write a new one anytime. Good question. There are 2 other documents that don't have anything to do with wealth transmission at all that estate planners routinely draft and that you should ask for if you want them. You don't have anything, but if you want one. One of them is called a living will, and I hate the name because it somehow implies that you're transmitting property during life. It has nothing to do with transmitting property. A living will is an advanced healthcare directive. What it says is, if I am in a permanent vegetative state and there's no hope that I'm ever going to recover, these are the circumstances under which I would want the respirator turned off. These are the circumstances under which I would want you to stop feeding me and giving me water. It sounds gruesome, but the truth is, most families are really appreciative if somebody signs one of these things because it gives them guidance in a very stressful situation. I was my father's attorney, in fact, not only for finances, but for healthcare as well. And I actually had to tell the doctor to turn the respirator off. And it was awful to have to do, but it was easier a little bit, at least, because I knew what he wanted. I knew that he would never have wanted to live as a vegetable. So I had the peace of mind to know that I was doing what he wanted. If you don't sign anything like this, you're putting your family in what may turn out to be a really uncomfortable situation. Because a medical professional has an obligation to keep people alive. A medical professional's job is not to kill people. So the medical professional is going to feel constrained to keep the respirator turned on, to make sure you're being artificially fed and given water, and to make sure that all of your functions that you can't handle yourself are being handled with machines for as long as necessary until somebody tells the medical professional to stop. If you would like the medical professional to stop sooner rather than later, you really need a living will that sets out how you want this sort of thing handled. Hand in hand with the living will is another durable power of attorney. Now, this can be the same document as the one for medical care. I'm sorry, as the one for finances, or it can be a separate one. Whether it's the same or different depends on whom you're going to appoint. I team teach it's called the Wills Clinic. I team teach a class, or I did until last year, a class with another trust and estates lawyer. We train senior law students to draft these documents for clients. And my co-teacher is one of 4 children. She is the only lawyer in the 4, and one of her siblings is a nurse practitioner. So when her parents asked her what they should do about these documents, she said, I'll be happy to be your attorney, in fact, for financial management, and you probably should appoint, and she named one of her siblings who is a business executive. You probably should appoint that person as the alternate. But when it comes to healthcare, you really need to appoint my sister, who's the nurse practitioner, because she knows what she's doing. So you want to find the right person for the job. If the right person for both jobs, power of attorney for healthcare and power of attorney for financial management, is the same person, you can put it all in one document. If the right person is 2 different people, it would make sense to just create 2 different documents. And again, an estate planning lawyer will tell you in your family situation what is the most efficient and least expensive way to handle all of these questions. No, actually, I think I will stop right there and see who has questions. I'm going to stop sharing, but so I can see everybody, but I can go back if I need to.
John, could you unmute everybody?
Yep. David, if you're the host, you have to unmute everybody, I think.
And you might have to do it individually as well.
Well, anyone should be able to unmute himself or herself by just pressing the little button in the lower left-hand corner.
Okay, Amy, I have a question for you.
Great.
So have you seen, and this is a hypothetical question, have you seen cases in the COVID-19 situations where the durable healthcare power of attorney have to be changed and updated constantly? Or, I mean, anything changed with regard to the law as far as this goes?
The law has not changed at all, but there are some questions that people don't think about that have become important. And in most cases, they are not answered in a living will or a durable power of attorney. The one that comes to my mind is, would you want to be placed on a ventilator or not?
Okay.
That's a question that would not be answered yes or no in your durable power of attorney. And that means that your attorney, in fact, would have to answer that question based on what he or she knew about you.
Okay.
But the attorney, in fact, would have the authority to answer the question. It would just be helpful if they knew what you personally would have preferred. Mm-hmm. And usually by the time someone needs a ventilator, it's too late to ask them because they can't speak.
Right, right.
Although that's newly relevant these days.
Yes, I think that's what Viren was talking about, that it's a COVID-19 question, so to speak. But no, durable powers of attorney have a long list of things. You know, do you want an autopsy? Is it okay if I share confidential information with the nursing home? All those sorts of questions. But the ventilator question is not answered in any of the standard forms that I've seen.
I see.
So I ask my clients now, and I add it, and that's what an estate planning lawyer should do.
So do you recommend updating, and this is just a general question,
yes.
Do you recommend updating the durable healthcare power of attorney to answer the ventilator question?
It's really up to you. It's one more piece of information for that family member that has to make difficult decisions.
Got it. Okay.
And it's particularly important if you think that your family members might think differently from you.
Right.
I have a lot of trouble getting my son to talk to me about what would happen if he needed to make this sort of decision for me, because he doesn't want to think about the fact that I might be incapable to take care of myself. But I know exactly what I want. So at this point, I have documents that say what I want, and I'm not sure that what he's going to want when he has to make the decision. But at least he'll know what I want, and then he'll have to choose.
My other unrelated question is regarding to selecting the executor of the estate. Now, I know there are different options available. You can select a trust department of a bank, or you can select somebody individually that you know in a family situation. Can you just tell us a little bit about that, selecting a executor of the estate?
Yes, and actually the executor and someone who is going to be a trustee might have different skills. So you might want to think about them differently.
Okay.
The executor of an estate has a fairly mundane job to do, and it's fairly short. It takes usually about a year, maybe even less. That person just has to think about what make a comprehensive list, not just think, but make an actual written list of all of your assets, figure out all your debts, pay the debts, and then distribute what's left to the people that you name in your will. And generally, unless you have a very complicated estate, that will take about a year. It's kind of tedious. There's a lot of little nitpicky stuff that you have to do for the probate court, but it's not difficult. If you have a family member who's willing to do tedious work, I would nominate a family member and an alternate family member to do that job. If there is no one who really wants to deal with the tedium, then you name a bank or trust company. And the first thing people say to me is, yes, but I'll have to pay a fee. I'm about to say something that I think will surprise you. You do have to pay a fee to name a bank or trust company.
Right.
But I'm not sure that I would assume that a family member would do it for free.
Right.
And here's why. It's tedious and it could take several months and it's a pain in the neck. And what you're going to end up with if you insist that the person act for free is somebody resentful who doesn't want to do the job and is doing it for free. So I often tell people to put a clause in their will that says, even if my brother does this work for me, I would like him to take compensation for the job, because that way he's a paid person and he gets the job done right. The other choice is to name a person and a bank or trust company.
Oh, I see. Okay.
And that's no, that's not one and then the other. That's two people acting jointly.
Oh, acting jointly. Oh, I see.
That's more common with trustees than with executors. But the reason for doing it is trustees have a lot of jobs to do. They have to invest the assets. They may keep them for a long period of time. They may have to make decisions about distributing property to one person and not another. And what you're doing by putting both a person and a bank in there is you're getting the financial acumen of the bank and the personal knowledge of the family of the person.
Okay.
So somebody would name a child and a bank, or a brother or a sister and a bank, something like that.
Okay.
So there's all kinds of choices. But a trustee is a more serious commitment that usually people are trustees for a long time, for somebody's life, or until somebody turns 35, or something like that. So it's even more important with that job that the person get compensated for doing it.
Okay. Thank you.
Sure.
I have a question, Amy.
I think you had a question.
Was somebody besides Kate?
David, did you have something?
Go ahead, Kate.
Okay. My question is,
Kate has a question.
yeah, I'm speaking. Should I go ahead?
Yeah, go ahead, Kate. It's fine.
Okay. Okay. It's confusing. I already have a will and most of these papers drawn up, but it was done like over 10 years ago. How often should these kinds of papers be looked at again with an attorney redone? Is there some rule of thumb, even if it's general?
Yeah, there's 2 rules of thumb, actually. One of them is I would do it just as an exercise to make sure everything's up to date once every 5 years.
5 years, okay.
And the main reason for doing it is you'd be surprised how much you forget about what you wrote in 2015 when you look at it in 2020. But the second thing is, and this is a more detailed rule of thumb, think about whether you need to change your estate plan in general anytime something very good happens to you or something very bad happens to you.
Okay.
Get a divorce, you need to change your will.
Yeah, sure.
Adopt a child, something very good. You adopt a child, you need to change your will.
Already done that a long time ago. Yes. Yeah, right. Okay, yes.
So
Gotcha.
that kind of thing.
Gotcha. Okay.
Somebody in your family dies and you inherit property from them, that's really something bad because you've lost a person, but
right.
you may have more property now, so you need to change your will.
Okay. Thank you.
Sure.
Laura, would we need to update it if the child situation changes, or could you just say all children get this thing or go to this individual?
For the guardian, all the children will be raised by this individual.
Yeah.
I would change it every time I had a child, just to make very clear that you want the same guardian for all the children.
Okay, so it would have to be then. Gotcha. Because I'm currently pregnant, so I don't know if I need to wait till after.
Congratulations.
Or we can just assume that they're all going to the same location.
Well, you can write a will that says, I want Mary and John Smith to raise any child of mine who is under the age of 18 when I die. You can do that and it will apply to all the children.
Okay.
So if you'd like to get it done now while you're thinking about it, you could definitely do it now. That'd be fine. But with a trust for the benefit of the children, I would just use that group clause. I would say I want all my property in a trust for the benefit of my children, and First Tennessee Bank or whatever you decide will manage the trust for the children. Sure.
Well, I've got one, and Mary's got one. Mary's got one too. Mine is the pros and cons of getting a real attorney versus legal Zoom.
I'm going to say something really sarcastic, but it's actually true. I could work full time for the rest of my life unscrambling the mess that people make trying to do documents on LegalZoom. And the problem is that you don't know what you don't know, so you're given choices to choose how to fill in the blanks in a document, and you really don't know what the consequences of making each of the choices is, but a lawyer does. So if you go to a lawyer, the lawyer will make the right choice having spoken to you and figured out what's best for your family. There are lawyers who will do nothing except fill in the blank too. I understand that, but you don't want that lawyer. You want the lawyer that actually talks to you for an hour or so and makes sure that he or she understands what you want to do. In that case, you're getting a document that's personally tailored to your family situation, and I just think that's much better than anything I've ever seen on LegalZoom.
Yeah.
Was it Mary Rogan? You had the other question?
Yeah.
Oh, there you are. Hi.
Thank you so much for doing this, Amy. It's really useful. So my question is about, I've seen it looks like at least half the folks who are on screen have a visitor. Usually, so far it's been cats that I've seen. I know at least one of our folks has a beautiful dog named Biscuit.
Yes, he's here.
He's here. There's Biscuit.
There he is.
Yeah. And I'm interested in information about trusts for being guardians for pets, trust for pets that you have.
Yes. And you're lucky because Tennessee has a very good statute for pet trusts, as I call them. I actually do a talk. It's one class session, so 75 minutes of our animals and the law class, which is taught by somebody else, but I come in once a semester and teach about estate planning for pet owners. You can name a guardian of the person, not only of your children, but of your pets. So you can name someone to be the guardian of Biscuit, or in my case, the one who just came across the screen was Phil. You don't need to know how he got that name. And you can name an alternate guardian for the animal, just as you name an alternate guardian for the child. You can also create a trust, which sounds funny when you first hear it. Create a trust.
No, it doesn't.
Go ahead, Kate. What were you going to say?
Oh, it can get very expensive, as we all know. Yes.
That's exactly it.
Don't want to saddle somebody with that. Yes.
You name a guardian, but you don't want to put that person to the expense of taking care of Biscuit. So you want to create a fund. And again, the pet guardian may not be the same person as the trustee, because the pet guardian obviously is somebody who loves the animal, and the trustee is somebody who manages money. So it's the same kind of question that you ask when you're deciding who should be the guardian of your children and who should be the trustee to manage the assets you're going to leave to raise them. And in Tennessee, it's very easy. You basically create the two trusts almost exactly the same way.
Thank you.
And you put both of them in your will, or just create.
What was the name of your cat?
Pardon me?
What was the name of your cat?
Oh, my cat's name is Phil, which is spelled F-I-L-F-I-L. His first human family were of Arabian ancestry, and Phil means black pepper in Arabic. And since he's a long-haired black cat and a little bit spicy, his personality is, we decided to keep the name Phil when we adopted him. The problem was someone in the first family is allergic to cats, and they didn't know that when they adopted him. So he was a friend of my son's.
Yeah.
And that's Phil. And Phil came, Mary will particularly laugh at this. Phil, when we were all teaching on Zoom last spring, Phil came to every single income tax class that I taught on Zoom. He would sit right here. And he would listen. So.
Thank you.
So there are three of you on this call. We can't see you on video. Do any of you have questions?
Oh, yes.
I don't have questions, but I just also want to thank Amy for doing this. So
yes, indeed.
My pleasure.
No questions from me. Thanks.
Okay, thanks. I've got a question for you. And this is going to seem like a shameless plug for the somebody needs to.
There's two voices.
Somebody doesn't know that they're not on mute, I think.
Yes, somebody has a radio on or something. There.
And now I don't know who had the question. Was it David?
Okay, I did, yeah. So this is going to seem like a shameless plug for the endowment fund, but be that as it may. So Jamie and I have a will, and right now the way it's structured is that if the money that we have isn't needed for long-term care, and it's likely that at least one of us will have the need for long-term care, and if any money is left over, it goes to Kevin, and we don't know how much that might be. But I asked, right now it's if he doesn't survive us and there's money, then it goes to various charities. But would there be a way to structure it so that above a certain amount, if there's money left after we're both gone, and above a certain amount, some goes to him, but then above that, it would go to the church and other charities, and then that's a window, and then above that, it goes to him. You see what I'm saying?
Yes.
In other words, so that he may not need all that money. He's successful, and so he doesn't need all the money that would have otherwise gone to our long-term care. And so is there a way to structure it so that he gets some, but the charity gets some over a certain amount?
Absolutely. And the way you structure it is you just say that. If at the death of the survivor of myself and my wife, there's $300,000. My son gets the first 100,000 and the rest goes to the following charity.
Yeah, just straightforward.
Again, as I said to Ted, I think I would let a lawyer write it because if you're not trained in the law, you can say things that you don't mean to say. So
Right.
I would let a lawyer write it, but it's not hard to do it at all. No.
Right.
Mary?
The discussion raised another question for me, and that is there, outside of legal, a standard
I'm sorry, Mary, but
one can with
I don't know
to
if this is
develop
talking.
work?
Mary, I can't understand you. I don't know if it's your video or your audio or mine, but
Okay. Do states tend to have a boilerplate type of information that one can start with?
states don't, but lawyers do. I have a financial checklist that I give to clients, and I say it would be really helpful if you came to our meeting next week with answers to these questions. But I don't know of a statute that has the list in it. I just know all the estate planning lawyers that I know have a list like that.
Yeah. Thank you.
What again was the meeting next week?
Sorry?
The meeting next week, what was that again?
Oh, Mary asked if states had a list of things you should think about when you do your estate planning. And my answer was, the week before I'm going to see a client, I send a list, but it's a list I created. It's not a state list. I don't know of any public list that has all the items you should think about when you're doing estate planning.
Okay, thanks.
Amy, I have a question. So at what is the threshold you recommend when you kind of migrate from this ordinary will to a living trust? Is there a threshold? Is there a monetary threshold? Or because if a person has the basics, the will, the durable power of healthcare and financial power of attorney, when do you actually migrate to a living trust?
You would use a living trust more depending on who your beneficiaries are and what your assets are than how much there is. If you have less, I guess if you had less than maybe $25,000 to leave at the end, you probably wouldn't want to create a trust. But then if the person who's going to get that $25,000 is a minor grandchild, who's only say 5 or 6 years old, well, you can't give $25,000 to a child, so you'd create a trust even then. And the living trust substitutes for a will, basically.
Right.
So you create the living trust now in anticipation that the $25,000 would be in trust for the grandchild when you die. So one of the reasons to create a living trust would be because your beneficiaries are going to need a trust anyway, and you might as well create it now and then avoid probate. The other reason for creating a living trust is because you might need help in old age. Okay. If you put your assets into a trust now and name somebody as trustee, then that person just automatically takes over when you can't handle your assets anymore, and it's a smoother transition. Okay. Again, I don't know that there's an absolute number, but probably if I had less than $25,000 to manage, I'd just use a power of attorney. I wouldn't do a living trust. But beyond that, I probably would do a living trust. And I'm guessing, because I don't really know, that you'd need several $100,000 before you'd meet the minimum fee that a bank would charge for a living trust. But the bank will tell you. I mean, you just call a bank and ask them what their minimum is, and they'll tell you. So you'd know. And then you could just name a person instead of a bank and pay less in commissions.
Thank you.
Sure.
Other questions? Well, Amy, I believe you've probably satisfied all of the uncertainties and questions I have about estate planning. Any final comments?
Just thank you.
Oh, you're welcome. And I doubt I answered all the uncertainties in an hour, but I hope I helped a little bit anyway.
Thank you very much.
Yes.
Thank you, Amy. Thank you.
Glad to do it.
This has been great, helpful. Thanks, Amy.
Yes, thank you. I appreciate it.
Glad to do it.
So, John, let me ask you a question. Do I need to stop the recording before we end the meeting?
I can do it if you want.
Okay, all right.